Okay, on behalf of the World Affairs Council of Austin and a lot of hard work on the parts of the people at Vinci High School and their Tateos up in New Hampshire area and Kevin in San Antonio. We are joined together to celebrate the January 27th Genocide Remembrance. And we're going to start out with a little speech from myself. Then we're going to introduce each person. We'll start with our judge, Tateos, and then we'll go to Dr. Kevin Cunningham in San Antonio, and then we'll go to Healy and introduce the students who are going to be doing the speaking today. Okay, with that set up, we're going to go ahead and let me give this little speech I prepared. Ladies and gentlemen, students, educators, and change makers, welcome. Today, January 27th, is not only a day to remember, it is a day to awaken. As the world pauses to honor 6 million lives that are lost in the Holocaust, we are reminded that silence in the face of evil is not neutral. It is complicit. Memorials are sacred, but they are not enough. Today we gather not to ritualize grief, but to ignite action, not to lament a past, but to confront a present that demands courage. We do not just remember genocide, we expose one. We do not do it by telling, and we will do it by telling the story, a story of defiance, resilience, and courage to question the experts. This story should strike a responsive chord for our friends out in the West Coast in Glendale. In 1923, in Warsaw, Wisconsin, Elroy Crazy Legs Hirsch was born to immigrant parents. He was not handed an opportunity, he won it. A star athlete, he earned a scholarship to the University of Wisconsin, but the world had more challenges for him. During World War II, he answered the nation's call by joining the U.S. Marine Corps, transferred to the University of Michigan for training. He played football, basketball, track, and baseball, 4 sports in 1 year. Then in 1946, playing professional ball for the Chicago Reds, a single moment changed everything. A brutal hit fractured his skull. The doctors, with cold certainty, delivered their verdict. You will never play football again. You may never fully recover. Accept it and move on. But Hirsch rejected the verdict, not out of arrogance or denial, but out of the belief that truth is always the opinion of the not always the opinion of the powerful. It is in the effort to reclaim it for yourself. His wife, Ruth, his coaches, and even his mentors all pled with him to stop. Too many risks, too little hope. But Hirsch persisted. He trained, he rebuilt his body and mind day after day, inch by inch. Then in 1951, a wide receiver for the Los Angeles Rams, he did the unthinkable. He shattered records, most receiving records in a season, 1,495 yards. Most touchdown receptions, 17. The league leader in catches. And he became a member of the world champion Los Angeles Rams in 1951. A man was told he would never play football again, became one of the greatest athletes of his generation. So I ask you, who was right? The experts who said no, or the man who dared to question them? The experts are wrong, and they are wrong again. This story is not just about football. It is a metaphor of our time. Today, we face a world where the truth is often buried under the weight of convenience, power, and inertia. When the experts and the world leaders look at the situation in the Caucasus and claim this is merely a border dispute or both sides are equally responsible, they repeat the same script that enabled the Holocaust. Waiting for diplomatic balances while the population is starved and purged is not neutrality, it is complicity. The truth, however, is clear. According to international legal experts, human rights organizations, and the harrowing testimonies of the displaced, the Armenian population, Artsakh, has been subjected to a systematic campaign of ethnic cleansing. Documentation is undeniable. A 10-month blockade of the Lakan corridor, starving 120,000 or more people, food, and medicine, the forced displacement of entire indigenous populations from the ancestral lands, the illegal seizure of homes, businesses, churches, and centuries of cultural heritage, the detention of political leaders now held in captivity in Baku, systematic dehumanization that precedes and accompanies and erases of people. This is not a mere clash of interests. This is a modern-day genocide. And yet, many people, the so-called experts, remain silent or prioritize energy security and the gas deals over human lives. Why? Because it's inconvenient, because pipelines matter more than people, because power protects power. Truly, this is a generation's inconvenient truth. But today, on International Holocaust Remembrance Day, we say no more. We are not here to repeat the rituals of memory, prevent them, and the need for them. Courtroom to the class. At Da Vinci High School in El Paso, a group of students asked a bold question. What if we were taught this way to the world? Through the Courtroom to Classroom project, these students studied international law, the United Nations Genocide Convention 1948, and the real-life testimonies of survivors. Then they did something radical. They put the perpetrators to ethnic cleansing on trial, a hearing at the International Criminal Court of Justice. In a mock hearing, they present evidence that Aktosh blockade and the September 2023 invasion. They question the legal definitions to intent to destroy and forced transfer. They argue with precision and passion that actions were taken against the Armenians during the legal criteria of genocide under the 1948 convention. The verdict, guilty. Not emotional outcry, not partisan politics, but the law itself. These students are the antidote to complacency. They show us that truth, when armed with knowledge, is unstoppable. For far too long, the story look as a frozen conflict or a territorial row. In September of 2023, the world watched as a lawful democratic republic was invaded. Within weeks, 100% of the residents were forcibly evicted. Today, 23 leaders of the country remain in Baku, facing sham trials under a legal system that does not recognize their sovereignty or human rights. The world calls it integration. We call it what it is, a total erasure of people from the land. Why does this matter? Because we accept the lie, integration, as inconclusive and too geopolitically sensitive to discuss. We become tools of the oppressor. Like Hirsch, like the students of El Paso, we must ask, who is right? The experts or the silenced truth for the sake of oil and gas or truth itself? The story of Crazy Legs Hirsch is not just a tale of physical triumph. It is a call to action. It's a question the experts reject complacency, to act even when the odds are stacked. The students of Da Vinci High School teach not what we are told, it is what we uncover. And when we uncover it, today we are the Crazy Leg Hirsch of our times. We are the students who refuse to be cowed down by power. We are the citizens who demand that governments choose integrity over energy deals, morality over diplomatic convenience. Let that be our legacy, that we did not wait for permission to act, that we followed the law, the evidence, and our shared humanity for the people of Aktosh and all those who suffer in silence while the world looks away. On this day of memory, we are haunted by the past, but we are not bound by it. Let us honor the 6 million people by acting for those currently facing erasure. Let us honor the victims of the Holocaust by denouncing the genocides of today. As Hirsch proved, when you challenge the experts and you believe the truth, you change the world. Join us by watching these students do something that the leaders of the world have failed to do. Stand up. What is right. Stand up to stop genocide and stand up for Aktosh now and forever. Thank you. Dr. Cunningham, if you could introduce the students and explain to them what we're going to do, and then I will introduce our judge for today, okay?
Let me let me unmute. All right, so what we have today is we have Jordan and Jimena, and we have Giovanna, and we have Elisa Pena. These are going to be the two different groups who are going to be arguing for the international case or between Artsakh and the country of Azerbaijan. So I'll give it up to them and allow them to intrigue you with all the greatness they have.
Okay, and then before that, we'll introduce our judge. Our judge today is a retired Armenian apostolic priest. Joe went on for probably the last quarter of a century. Very dear to my heart, and I've worked with him with his Sunday school program. Actually, have been around the world. It's really kind of cool. Tateos, if you could say something a little bit about your background a little bit, please.
Thank you, Michael. Good morning to students and to all of you. Thank you for participating in this. Forget about me. My background, I'm an Armenian priest. That's enough. I'm impressed with what you're doing. Very impressed with what you're doing. As an Armenian, I would normally be interested in matters that pertain to my people. But I am impressed, amazed that folks who have real no connection to my background, to the Armenian people, are getting involved in such a discussion and in such a project. Thank you. On behalf of my father, who was a survivor of the genocide of 1915, and all those who survived, came to this country and built new lives for themselves. Thank you for what you're doing. For all those people that escaped from the atrocities that began right after the fall of the Soviet Union in Sumgait in Azerbaijan, in Baku, all those who survived and were able to escape and come to this country and throughout the world to create new lives. Again, I say to you, thank you for what you're doing. And in memory of all those who perished in the genocide of 1915 and even before, in Adana in 1893, in Baku, Sumgait, and the rest of Azerbaijan, those who died, who were laid to rest in that country, and yet whose graves were desecrated by the Azeri people. I say to you, thank you for remembering them and doing what you are doing. God bless you all, and have fun in what you're doing. Have fun in the sense that it should be a joy to present truth to the world, not have fun in a happy sort of a way, but in a way that you are accomplishing something that not all seek to accomplish. Don't ever stop. Don't ever stop seeking the truth. Don't ever stop speaking the truth, no matter where it takes you. God bless you all. Thank you for this privilege too, Michael, for being a part of it.
Thank you very much, Tateos, and we really appreciate it and appreciate those comments. It's very important to us to kind of show exactly what will happen by just telling the truth. I think truth speaks to truth. You don't necessarily have to be from Armenia to understand what it is. And it's really sad. I think our commentary in today's society that many of our politicians don't really even seek out the truth anymore, and they just go to whatever. And by trying to teach the students, that's how it's going to eventually change our politicians in the future or change our future, and that's the only way to stop this. So with that in mind, let's start with, we'll have two different groups. Each will be two speakers. You can ask questions when they start. They'll introduce themselves. We'll start with Jordan and Amena, then we'll go to Giovanna and Isa. Okay, Jordan, go ahead.
Okay, so hi everyone. My name is Jordan. I am a junior at Da Vinci School of Science and the Arts and the vice president of the debate club. My teammate is Jimena, and we're very excited to be here today.
Hello, my name is Jimena. I'm currently a senior in Da Vinci, and I am a great member of this foundation, and I'm really excited to be here.
Let's just go to our speeches because we're breaking up.
Hello, everyone. My name is
So,
Giovanna
first
Macharia. I
speaker,
am also a
Jordan.
senior at Da Vinci School for Science and the Arts. I am the founder and the president of this debate club. This is a very important day for us, and we are more than excited to be here presenting this case.
My name is Elisa Pina. I am a sophomore in Da Vinci College at El Paso. And this society, the Debate Society, is very new to me, and I'm glad I was able to make the wonderful experiences I've had.
Very good. We'll start with Jordan first, and let's go.
So I am the second, so my teammate Jimena will go first.
Great.
Case People of Artsakh, Azerbaijan. Date January 27, 2026. Introduction. Signposting. Opening statement. May it please the court, today we address a great breach of international law. The unlawful trial and conviction of 23 citizens of Artsakh by Azerbaijan under its domestic criminal code. This case is not merely about individual injustice. It is about the principle that no state may unilaterally impose its jurisdiction over the citizens of a self-governing entity without lawful basis under international law. Roadmap. First, I will demonstrate that Azerbaijan's actions violated the principle of sovereignty, which protects the political authority of self-determining peoples. Second, I will show that the doctrine of sovereign immunity precluded Azerbaijan from exercising criminal jurisdiction over these individuals in the given circumstances. Third, I will explain why the status quo allowing such trials undermines the international legal order and is therefore unlawful. Argument 1. Violation of sovereignty. Signpost. I turn now to my first submission. Azerbaijan prosecution of Artsakh citizens violated the principle of sovereignty, a cornerstone of the UN Charter and customary international law. A. Legal principle. Sovereignty entails the exclusive right of a political community to govern its own citizens and territory without external interference. Enshrined in Article 2.1 of the UN Charter, the organization is based on the principle of the sovereign equality of all its members. Sovereignty extends to peoples exercising to self-determination, as affirmed by the ICJ's Nambia Advisory Opinion, 1971. B. Relevant case law. 1. Island of Palma's case, Netherlands v. USA, 1928. Permanent Court of Arbitration. Principle. Sovereignty means independence in regards to a portion of the globe. It excludes the exercise of authority by any other state. Application. Azerbaijan's application of its own criminal law to Artsakh citizens is analogous to the wrongful imposition of sovereign authority over territory, not under its administrative control at the time of the alleged acts. Why our argument is stronger. Unlike in Palmas, where sovereignty was disputed but resolved through effective control, Artsakh's people had disputed Artsakh people had functioning institutions of self-governance, making Azerbaijan's jurisdiction claim weaker. 2. ICJ military and paramilitary activities. in and against Nicaragua, Nicaragua v. United States, 1986. Principle: respect for sovereignty prohibits direct or indirect intervention in the internal affairs of another entity. Application: the trial of Artsakh citizens constitutes direct intervention in the internal jurisdictional affairs of Artsakh. Better than status quo. Current practice of trying such individuals undermines the prohibition on intervention and sets a precedent for coercive legal assimilation. 3. ICJ advisory opinion on the legal consequences of the separation of the Chagos Archipelago, 2019. Principle: the right to self-determination must be respected. Acts contrary to it are unlawful. Application: prosecuting Artsakh citizens under Azerbaijani law disregards their political will and identity as a self-determining people. Why this status quo is so illegal? It normalizes the erosion of self-determination through criminal law as a political weapon. C. Why the status quo is illegal under sovereignty. It destabilizes international order. If states can prosecute individuals from self-governing territories without consent, it erodes the mutual respect for sovereignty that underpins the UN system. Encourages political prosecution. Opens the door for states to use criminal trials against political opponents for disputed regions. Contrary to customary international law. Long-lasting practice holds that jurisdiction is territorial and personal, not extraterritorial without consent. Third, Argument 2. Violation of sovereign immunity. Signpost. I turn to my second submission. The prosecutors violated the doctrine of sovereign immunity as it applies to representatives and officials of a political entity. A. Legal principle. Sovereign immunity protects not only states, but also their officials when acting in an official capacity. Rooted in the maxim partem partem non habet imperium, equals have not authority over each other. Extends to protect officials of entities recognized as having attributes of sovereign or self-governance. B. Relevant case law. 1. ICJ arrest warrant of 11th April 2000. Democratic Republic of the Congo v. Belgium. Principle: incumbent foreign ministers enjoy full immunity from criminal jurisdiction in foreign courts, regardless of allegations. Application: many of the 23 Artsakh citizens held officially or quasi-official roles in their administration, thus entitled to functional immunity. Why is it stronger? Extending immunity here preserves the functional independence of self-governing entities. The status quo strips that protection and politicizes justice. 2. Jurisdictional immunities of the state. Germany v. Italy. Greece intervening. ICJ 2012. Principle: a state may not be subjected to the jurisdiction of another state's courts without consent. Application: the prosecution of Artsakh citizens for official act is tantamount to prosecuting the entity itself, a breach of jurisdictional immunity. Better than status quo. A review aligns with ICJ's precedent, whereas the status quo is an unlawful expansion of domestic jurisdiction over foreign officials. 3. Pinochet, number 3, 2000. 1 AC 147 UK House of Lords. Principle: while functional immunity can be lifted for international crimes, domestic political offenses do not justify bypassing immunity. Application: The alleged crimes in this case were prosecuted under Azerbaijani law, not under universally recognized international crimes. Why status quo is illegal? It conflates domestic political offenses with international crimes, eroding the protective scope of sovereign immunity. C. Why the status quo is illegal under sovereign immunity. It breaks international consensus. Immunity is a procedural guarantee essential to stable relations. Eroding it invites reciprocal violations. Shows political representations. Leaders and officials from self-governing territories risk arrest and trial when engaging internationally. Violates principle of equality. Applying domestic law to foreign officials without consent contradicts pari passu. Rebuttal to potential counterarguments. Signpost. Before concluding, I will briefly address potential counterarguments. Counterargument 1. Azerbaijan claims full sovereignty over Artsakh under territorial integrity. Response. Territorial integrity is not absolute. Self-determination and effective governance limits a state's ability to impose law extraterritorially. See Shago's advisory opinion. Counterargument 2. The crimes were serious and required prosecution. Response. Seriousness does not override jurisdictional limits. Only international tribunals or the competent authority of the territory may prosecute. Conclusion. Signpost. In conclusion, the convictions of the 23 Artsakh citizens were unlawful on 2 counts. They violated the principle of sovereignty and the doctrine of sovereign immunity. Final quote from Judge Alvarez in Corfusiano ICJ. The respect due to the sovereignty of the states must be absolute. Now, a prayer for relief. The court should declare the convictions null and void, and affirm that Azerbaijan's exercise of jurisdiction in this matter was contrary to international law. Thank you.
Go ahead.
Now, the second speaker, my friend and teammate Jordan, will start speaking. One moment, please.
$59.59.
Madam President, members of the court, this case is not just about politics, it is about law. It is about whether the rule of law can be bent to serve political ends. We submit that the trial and the conviction of 23 Artsakh citizens under Azerbaijani rule was both procedurally and substantially unlawful, in violation of binding international legal principles and the ICJ's own jurisprudence. We will demonstrate first that Azerbaijan's reliance on certain treaties to justify its exercise of jurisdiction was invalid under international law. These are illegal treaties within the meaning of the Vienna Convention on the Law of Treaties, VCLT. Second, that Azerbaijan lacked the legal jurisdiction to prosecute these individuals under both domestic and international law. Third, we will preempt and rebut the counterarguments concerning territorial integrity and the non-recognition doctrine. Argument 1, the invalidity of the treaties. I will begin by addressing the legal foundation Azerbaijan claims under certain bilateral and post-conflict agreements, and why those instruments cannot confer unlawful jurisdiction. A. Applicable legal principle. Vienna Convention on the Law of Treaties, 1969, Articles 51 to 53. Treaties procured by coercion of a representative state or concluded in violation of preemptory norms are void. B. Case law authorities. Nambia Advisory Opinion, ICJ 1971, Legal consequences for state of the continued presence of South Africa in Namibia. Notwithstanding Security Council Resolution 276, 1970. Application. The court held that international instruments arising from illegal occupation have no legal effect. Similarly, any Azerbaijani reliance on agreements concluded under military duress or in contravention of self-determination norms is void. Our argument is stronger, just as South Africa's administration of Namibia was void. Azerbaijan's post-2020 arrangements signed under coercive military conditions cannot justify prosecuting Artsakh residents. Second, Alan Island's case, Report of the Commission Juris 1920. Application. The Commission recognized that agreements affecting a territory's status must respect the principle of self-determination. Our case mirrors this. Agreements ignoring Artsakh's rights to self-determination lacks legitimacy. The status quo is illegal because Azerbaijan's invocation of such agreements is equivalent to overriding the population's rights without lawful consent. Third, Kadar v. Hungary, European Court of Human Rights, 2012. Application. The ECHR held that international agreements or actions violating fundamental human rights cannot be enforced domestically. Azerbaijan's prosecution violates fair trial standards and liberty rights. This supports us because even if Azerbaijan claims treaty-based jurisdiction, those instruments cannot validate a process that breaches peremptory norms. Conclusion of this point. A treaty or agreement born of illegality cannot breed legality into subsequent acts. The convictions here rest on sand, not stone. Argument 2, lack of jurisdiction. I now turn to the second pillar of our submission. Azerbaijan simply did not have lawful criminal jurisdiction over these individuals under international law. A. Applicable legal principle. Jurisdiction in criminal matters is primarily territorial but must also be exercised in accordance with international law. Jurisdiction cannot be asserted where sovereignty over territory is disputed and where the acts alleged occurred outside the prosecuting state's lawful control. B. Case law authorities. First, the Lotus case, France versus Turkey, PCIJ 1927. Application. The court held that the jurisdiction is permissible only where there is a recognized connecting link. Azerbaijan's link is disputed territory, not recognized as its sovereign territory by many states. In Lotus, jurisdiction was exercised over a clear territorial link. Here, that link is absent or internationally contested. Second, arrest warrant case. The Democratic Republic of the Congo versus Belgium, ICJ 2002. Application. The ICJ stressed limits on a state's extraterritorial jurisdiction in criminal matters. Azerbaijan's prosecution of Artsakh citizens for acts committed in Artsakh is extraterritorial in effect, given the lack of recognized sovereignty during the relevant period. Why the status quo is illegal. Exercising jurisdiction without lawful sovereignty or consent violates international norms. The Loizado versus Turkey ECHR. Application. The court found that the jurisdiction flows from effective control, but such control must be lawful under international law. Azerbaijan's control after recent conflict was neither long-standing nor internationally sanctioned at the time of alleged offenses. Why this matters. Mere factual control does not equal lawful jurisdiction. Legality is essential. The law of jurisdiction is not a weapon for opportunistic prosecution. It is a safeguard against the very overreach we see here. Third, anticipating and rebutting counterarguments. Before concluding, I will address two counterarguments that the respondent is likely to raise: territorial integrity and non-recognition. A. Territorial integrity. Azerbaijan will assert that Artsakh lies within internationally recognized borders, thus granting it jurisdiction. Rebuttal. First, East Timor, Portugal versus Australia, ICJ 1995. The ICJ confirmed that territorial integrity cannot override the right to self-determination. Second, the principle of territorial integrity protects state from external aggression, not from internal demands for self-determination where fundamental rights are at stake. And third, Azerbaijan's invocation ignores the non-mere principle. Actions in violation of preemptory norms cannot be legitimized by territorial claims. Territorial integrity is a shield against aggression, not a sword for repression. B. Non-recognition doctrine. Counterargument. The respondent may argue that since Artsakh is not recognized as a state, its people are subject to Azerbaijani law. Rebuttal. First, advisory opinion on Konosovo, ICJ 2010. The court confirmed that declarations of independence are not prohibited by international law. Second, non-recognition does not extinguish rights under international humanitarian law and human rights law. Third, the lack of recognition does not legitimize breaches of fair trial rights, arbitrary detention, or the use of coerced treaties. Non-recognition is not a license to ignore the law. It is a call to apply it to more scrupulously. 4. Why our position is superior to the status quo. Finally, I will explain why our interpretation of the law is both legally correct and necessary to preserve the international legal order. First, rule of law. Upholding void treaties or unlawful jurisdiction undermines the VCLT and ICJ's own precedent. Second, human rights protection. Our stance affirms that individuals' rights to survive political disputes over territory. Third, international stability. Allowing prosecutions based on coerced agreements and contested jurisdiction invites abuse in other conflicts. Conclusion. Members of the court, the ICJ has long stood as the guardian of legality over expedientiary. The convictions of the 23 Artsakh citizens were not the acts of lawful sovereign exercising legitimate jurisdiction. They were the acts of a state seeking to cement political gains through judicial means. This court should reaffirm that treaties born of coercion are void, that jurisdiction must be as lawful as well as factual, and that counterarguments rooted in territorial integrity and non-recognition cannot override preemptory norms. To hold otherwise would be to let might make right, and that is not the law. We seek declaration that Azerbaijan's prosecution of the 23 Artsakh citizens was unlawful, order for immediate annulment of convictions and release of detainees, and declaration that any treaty or agreement purporting to justify these prosecutions is void ab initio. Thank you.
Good. If there are no questions, let's go to the next speaker, the next group, and then we'll have some questions. Tateos, would you like to ask any questions? I know it may be difficult to understand, but do you have any questions for this group?
I have several questions.
Go ahead.
Do I ask after each group goes?
Yeah, that'd be good. Go ahead.
All right. We'll be looking forward to your questions. For now, my name is Giovanna Baccaria, and I am the first speaker for this group.
Giovanni, let's go ahead and let them ask their questions. He's going to ask the questions at the end, so let them answer their questions, then we'll go to you, okay?
Oh, I understand. Thank you.
Okay, thank you.
You want me to ask my questions now, you said, Michael? Okay. I was impressed.
Okay, thank you.
I want to express my questions as one who is ignorant of the whole situation, not one who has a background knowledge of it. You gave some definitions of international law, different treaties and so on and so forth. How did you come about comparing what you brought up to the situation in Artsakh?
Well, we wanted to find situations, historical situations and conflicts that would be similar to the one that we saw in Azerbaijan and Artsakh. And we wanted to see, we wanted to take specific scenarios, specifically how the people of Artsakh were to be taken from their homes. And we wanted to find cases that hit each of those points specifically so that we would be able to create a solid case.
Okay. Has Artsakh been recognized by any international organization as a legitimate entity by itself and not as a part of Azerbaijan?
May you please repeat the question?
Has Artsakh, the conclave of Artsakh, been recognized by any international organization as an independent conclave, republic, or any other type of landmass?
Well, when the Soviet Union released Azerbaijan and Artsakh from when the Soviet Union was dissolved, they were able to form their own unique sovereign identity around that.
Who's
So
they?
Azerbaijan and Armenia and Artsakh.
So the country of Azerbaijan was able to,
To separate from the Soviet Union. Yes.
Yes.
okay, of which Artsakh was a part of.
Technically, yes.
Not technically, it was. Right?
Yes.
Yes.
So my question again is, has any international organization, such as the United Nations, for example, recognized Artsakh as an independent entity?
By the information we know that the treaty that was signed was illegal as it was forced. And
What treaty is
this,
that?
I apologize, I
The
do not know.
1920 treaty. The treaty in 1920.
1920 treaty. Yes.
1920 treaty?
I don't believe that's the name, but the year was in 1920.
Okay, go ahead.
And according to the UN, as this was illegal, this makes Artsakh independent and sovereign from Azerbaijan.
But it's not recognized by international law as such, correct?
I believe that you do not need to be recognized by other nations to be considered a country. However, because they were both separate sovereign entities, they can be able to function and exist as two different countries. But what Azerbaijan is trying to do is to find a back door around that and to say that because they were once a complete country when they were under the Soviet Union, they can still continue to be that country under their laws.
I agree that there were criminal acts committed during the late 1980s in Sumgait and Baku and so forth. But if Artsakh has not been recognized as an independent nation or entity, then the actions of the people of Azerbaijan against the Armenian people would be internal criminal acts and not internationally judged, correct?
No,
Why?
because the way that they went about having the 23 Artsakh citizens removed from their homes in the night is an international violation of what the ICJ has come to terms with. So it is not a legal right or within their jurisdiction to be able to do that. So by allowing Azerbaijan to commit these grave offenses to the Armenian and Artsakh citizens, this is basically telling the whole rest of the world that, oh, okay, this is okay. You can do this as well.
And what they did, was it representative of the officials of the Azerbaijani government or the acts of murder and other crimes that they committed done on their own, which is not subject to any international violation, correct?
No.
That's all, just no?
I'm sorry, can you rephrase the question? I don't feel I understand.
Said the acts that these people committed, the acts of murder and so on, against the Armenian people. Um, why should they be considered international violations rather than internal if Azerbaijan never recognized Artsakh as independent and neither had any other international agencies such as the United Nations? Criminals are criminals, but there's criminal prosecution internationally and there's criminal prosecution internally.
You are correct. This is the political prosecution, and it is a great violation of the human rights. This is not something we want to see the other countries repeat in other parts of the world. So that is why this is resolved internationally. We do not want more genocides, and that's why we are here right now. The treaty that we mentioned before is the 1920 Treaty of Azerbaijan's bases that control Artsakh. This was the illegal treaty that was forced and therefore recognized as unlawful or not official.
What does that treaty say specifically to the people of Artsakh? Or at that time was recognized as Nagorno-Karabakh. What specifically does it say that ensures the guaranteed rights of the Armenians? Do you know?
Can you rephrase the question, please?
Sure. The treaty that you mentioned mentions the Armenians in Nagorno-Karabakh specifically and their rights, correct?
Well, that Azerbaijan's invocation of such agreements is equivalent to overriding the population's right with unlawful consent.
What rights did the Armenians have under that treaty in Karabakh?
The right to self-determination, and which lacks legitimacy.
What does self-determination mean?
Self-determination refers to the right to determine something for yourself.
To what?
The right to determine something for yourself.
I'm not hearing the last part of your phrase. Say it one more time. It determines what?
The right to determine something for yourself within a legal standpoint.
Okay. Thank you.
Thank you.
Thank you.
Okay, let's go to Giovanni, please.
Good morning, everyone. Pardon. Again, my name is Giovanna Macharia. I am the first speaker of this group, and I will begin with my signpost. May it please the court. Today, we address the grave breach of international law, the unlawful trial and conviction of 23 citizens of Artsakh by Azerbaijan under its domestic and criminal code.
May I just interrupt you for 1 second? Can you speak
course.
just a little slower?
Oh, yes. Yes, I shall.
Coming out as one long sentence. I'm an old, I have to listen very carefully. So,
All right. Let me
oh,
do that.
Thank you.
May it please the court. Today, we address a grave breach of international law, the unlawful trial and conviction of 23 citizens of Artsakh by Azerbaijan under its domestic criminal code. This case is not merely about individual injustice. It is about the principle that no state may unilaterally impose its jurisdiction over the citizens of a self-governing entity without lawful basis under international law. First, I will demonstrate that Azerbaijan's actions have violated the principle of sovereignty, which protects the political authority of self-determining peoples. Second, I will show that the doctrine of sovereign immunity precluded Azerbaijan from exercising criminal jurisdiction over these individuals in the given circumstances. Finally, I will explain why the status quo allowing such trials undermines the international legal order and is therefore unlawful. My first argument is of the violation of sovereignty. I turn now to my first submission. Azerbaijan's prosecution of Artsakh citizens violated the principle of sovereignty, a cornerstone of the UN Charter and customary international law. A. Legal principle. Sovereignty entails the exclusive right of a political community to govern its own citizens and territory without external interference. Ensuring in Article 2, verse 1 of the UN Charter states, the organization is based on the principle of sovereign equality to all its members. Sovereignty extends to the people exercising the right of self-determination, as affirmed by the ICJ's Nambinia's advisory opinion, 1971. I will now state 3 case laws coinciding with this. The Island of Palmas case, Netherlands versus United States, 1923. Permanent Court of Attribution. Principle. Sovereignty means independence in regard to a portion of the globe. It extends to the exercise of authority by another state. Application. Azerbaijan's application of its own criminal law to Artsakh citizens is analogous to the wrongful imposition of sovereign authority over territory not under its administrative control at the time of the alleged acts. Our argument is stronger because unlike Palmas, where sovereignty was disputed but resolved through effective control, Artsakh's people had functioning institutions and self-governance, making Azerbaijan's jurisdictional claim weaker. The second case, ICJ, military and parliamentary activities in and against Nigeria. Nicaragua versus United States, 1986. Principle. Respect for sovereignty prohibits direct or indirect intervention in the internal affairs of another's entity. Application. The trial of Artsakh citizens constitutes direct intervention in the internal jurisdictional affairs of Artsakh. Why this is better than the status quo? Current practice of trying such individuals undermines the prohibition of intervention and sets a precedence for coercive legal assimilation. The third case, ICJ advisory opinion on legal consequences of the separation of Chagos, 2019. Principle. The right of self-determination must be respected. Acts contrary to it are unlawful. Application. Prosecuting Artsakh's people under Azerbaijan's law disregards their political will and identity as a self-determining people. Why the status quo is illegal? This is because it normalizes the erosion of self-determination through criminal law as a political weapon. Now I will state why the status quo is illegal under sovereignty. It destabilizes international order. If states can prosecute individuals from self-governing territories without consent, it erodes the mutual respect for sovereignty that underpins the UN system. It encourages political prosecutions, open doors for states to use criminal trials against political opponents from disputed regions. It is contrary to customary international law. Long-standing principles hold that jurisdiction is territorial and personal, not extraterritorial without consent. My second argument is now of the violation of sovereign immunity. Signpost. I will now turn to my second submission. The prosecutions violate the doctrine of sovereign immunity, as it applies to representatives and officials of a political entity. A. Legal principle. Sovereign immunity protects not only states, but the officials when acting in an official capacity. Rooted in the maxi per in parlam not happen inter parallel, the Latin quote meaning equals have no authority over each other. It extends to protect officials of entities recognized as having attributes of sovereignty or self-governance. B. Relevant case laws. Again, 3 case laws defending my argument. Case law number 1, ICJ, arrest warrant of 11th of April 2000, Democratic Republic of Congo versus Belgium. My principle: inclement foreign ministers enjoy full immunity of criminal jurisdiction over foreign courts, regardless of allegations. Application: many of the 23 Artsakh citizens held official or quasi-official roles in the administration, thus entitled to functional immunity. Our argument is stronger because extending immunity here preserves the functional independence of self-governing entities. The status quo strips that protection and politicizes justice. Second case law, jurisdictional immunities of the state. Germany versus Italy and Greece intervening. ICJ 2012. Principle: a state may not be subject to the jurisdiction of another state's court without consent. Application: the prosecution of Artsakh's people for official acts is tantamount to prosecuting the entity itself, a breach of jurisdictional immunity. And why that is better than the status quo? Our view aligns with ICJ's precedent, whereas the status quo is an unlawful expansion of domestic jurisdiction over foreign officials. Our third case law is Pinach 2001 AC 147, UK House of Lords. Principle: while functional immunity can be lifted for international crimes, domestic political offenses do not justify bypassing immunity. Application: the alleged crimes in this case were prosecuted under Azerbaijan's domestic law, not universally recognized international crimes. Why the status quo is illegal? It conflates domestic political offenses with international crimes. It erodes the protective scope of sovereign immunity. Why the status quo is illegal under sovereign immunity? It breaks international concessions. Immunity is a procedural guarantee essential to stable relations. Eroding it invites repercussional violations. It chills political representation. Leaders and officials from self-governing territories risk arrest and trial while engaging internationally. It violates the principle of equality. Applying domestic law to foreign officials without consent contradicts with par in parlem. Again, the Latin quote. I will now refer to rebuttals to potential counterarguments. Before concluding, I will briefly address potential counterarguments. The first would be that Azerbaijan claims full authority over Artsakh under territorial integrity. My response to this is that territorial integrity is not absolute. Self-determination and effective governance limits a state's ability to impose laws extraterritorially. The second counter-argument would be that crimes were too serious and required prosecution. However, my response to this is that seriousness does not override jurisdictional limits. Only international tribunals or competent authority of the territory may prosecute. In conclusion, the conviction of these 23 Artsakh citizens were unlawful on 2 counts. They violated the principle of sovereignty and the doctrine of sovereign immunity. My final quote from Judge Alvarez in Corfu Channel ICJ is that the respect due to the sovereignty of one state must be absolute. And my prayer of relief is that the court should declare the convictions null and void, and that affirms Azerbaijan's exercise of jurisdiction in this matter was contrary to international law. Thank you. This is Giovanna Macharia, first speaker, and I will now turn to my partner, Elisa Pina, to state her second speaker case. Elisa Pina.
Hello again, my name is Elisa Pina, and I will be presenting the second argument. Madam President, members of the court, this case is not about politics. It is about law. It is about whether the rule of law can be bent to serve political ends. We submit that the trial and the conviction of 23 Artsakh citizens under Azerbaijani law was both procedurally and subsequently unlawful, in violation of binding international legal principles and the ICJ's own jurisprudence. We will demonstrate, first, that Azerbaijan's reliance on certain treaties to justify its exercise of jurisdiction was invalid under international law. These are illegal treaties within the meaning of the Vienna Convention on the Law of Treaties. Second, that Azerbaijan lacked legal jurisdiction to prosecute these individuals under both domestic and international law. Third, we will preempt and rebut the counter-arguments. Sorry, one sec.
A moment for the
Technical
difficulties.
Third, we will preempt and rebut the counter-arguments concerning territorial and integrity and the non-recognition doctrine. Argument 1. Invalidity of treaties. I will begin by addressing the illegal foundation of Azerbaijan's claims under certain bilateral and post-conflict agreements, and why those instruments cannot confer lawful jurisdiction. Applicable legal principle. Vienna Convention on the Law of Treaties, 1969, Articles 51 through 53, treaties procured by coercion of a representative of a state or concluded in violation of preemptory norms are void. B. Case law authorities. Nambia Advisory Opinion, ICJ, 1971. Legal consequences for states of the continued presence of South Africa in Nambia, notwithstanding Security Council Resolution 276, 1970. Application. The court held that international instruments arising from an illegal occupation have no legal effect. Similarly, Azerbaijan's reliance on agreements concluded after military duress or in contravention of self-determination norms is void. Our argument is stronger. Just as South Africa's admission of Nambia was void, Azerbaijan's post-2020 arrangements signed under coercive military conditions cannot justify prosecuting Artsakh's residents. A Land Islands Case. Report of the Commissions of Jurists, 1920. Application. The Commission recognized that agreements affecting a territory's status must respect the principle of self-determination. Our case mirrors this. In agreements ignoring Artsakh's right to self-determination lack legitimacy. The status quo is illegal. Azerbaijan's invocation of such agreement is equivalent to overriding the population's right without lawful consent. Kaidar versus Hungary. European Court of Human Rights, 2012. The ECHR held that international agreements or actions violating the fundamental human rights cannot be enforced domestically. Azerbaijan's prosecution violates fair trial standards and liberty rights. Why this supports us? Even if Azerbaijan claims that treaty-based jurisdiction, those instruments cannot violate a process that breaches preemptory norms. A treaty or argument born of illegality cannot breathe legality into subsequent acts. These convictions here rest on sand, not stone. Argument 2. Lack of jurisdiction. I will now turn to the second pillar of our submission. Azerbaijan simply did not have lawful criminal jurisdiction over these individuals under international law. A. Applicable legal principle. Jurisdiction in criminal matters is primarily territorial, but it must also be exercised in accordance with international law. Jurisdiction cannot be asserted where sovereignty over the territory is disputed, and where the acts alleged occurred outside the prosecuting state's lawful control. B. Case law authorities. First, the Lotus case, France versus Turkey, PCIJ 1927. The court held that jurisdiction is presumable only where there is a recognized connecting link. Azerbaijan's link is disputed territory, not recognized as its sovereign territory by many states. Our argument prevails because in Lotus, jurisdiction was exercised over a clear territorial link. Here, that link is absent or internationally contested. Second, arrest warrant case, Democratic Republic of the Congo versus Belgium, ICJ 2002. The ICJ stressed limits on states' extraterritorial jurisdiction in criminal matters. Azerbaijan's prosecution of Artsakh's citizens for acts committed against Artsakh is extraterritorial in effect, given the lack of recognized sovereignty during the relevant period. The status quo is illegal because exercising jurisdiction without lawful sovereignty or consent violates international norms. Lutzu versus Turkey. Application. The court found that jurisdiction flows from effective control, but such control must be lawful under international law. Azerbaijan's control after recent conflict was neither long-standing nor internationally sanctioned at the time of the alleged offenses. This matters because mere factual control does not equal lawful jurisdiction. Legality is essential. The law of jurisdiction is not a weapon for opportunistic prosecution. It is a safeguard against the very overreach we see here. Anticipating and rebutting counterarguments. I will address two counterarguments that the respondent is likely to raise: territorial integrity and non-recognition. Territorial integrity. Azerbaijan will assert that Artsakh lies within its internationally reclosed borders, thus granting it jurisdiction. My rebuttal is, in case 1, East Timor, Portugal versus Australia, ICJ 1995, the ICJ confirmed that territorial integrity cannot override the right to self-determination. The principle of territorial integrity protects states from international aggression, not from international demands for self-determination where fundamental rights are at stake. Azerbaijan's invocation ignores the Nambia principle. Actions in violations of preemptory norms cannot be legitimized by territorial claims. Territorial integrity is a shield against aggression, not a sword for repression. B. Non-recognition doctrine. The respondent may argue that the Artsakh is not recognized as a state. Its people are subject to Azerbaijan's law. Rebuttal. Advisory opinion on Kosovo, ICJ 2010. The court confirmed that declarations of independence are not prohibited by international law. Non-recognition does not extinguish the rights under international humanitarian law and human rights law. Third, the lack of recognition does not legitimize breaches of fair trial rights, arbitrary detention, or the use of coercive treaties. Non-recognition is not a license to ignore the law. It is a call to apply it more intently. Why our position is superior to the status quo. Finally, I will explain why the interpretation of the law is both legally correct and necessary to preserve the international legal order. First, the rule of law. Upholding void treaties or unlawful jurisdiction undermines the VCILT and the ICJ's own jurisprudence. 2. Human right and protection. Our stance affirms that it's the individual's right to survive political disputes over territory. 3rd, international stability. Allowing prosecutions based on coerced arguments and contested jurisdiction invites abuse in other conflicts. Conclusion. Members of the court, the ICJ has long stood as the guardian of legality over expediency. The convictions of 23 Artsakh citizens were not the acts of lawful sovereign exercising legitimate jurisdiction. They were the acts of states seeking to cement political gains through judicial means. The court should reaffirm that treaties born in coercion are void, that the jurisdiction must be lawful and as well as factual, that the counter-arguments rooted in territorial integrity and non-recognition cannot override preemptory notes. To hold otherwise would let might take right, and that is not the law. Our relief sought is the declaration that the Azerbaijan's prosecution of the 23 Artsakh citizens was unlawful. Order for immediate annulment of the convictions and release of detainees. Declaration that any treaty or agreement purporting that to justify that the prosecutions is void ab initio. Thank you.
Again, that is my teammate, Elisa Pina, the second speaker. And if you have any questions, please go ahead.
Tateos, do you have any questions?
I do. I have one. You said that the treaty was coerced.
Yes.
How was it coerced?
It violates sovereignty, which states that a self-governing state has can be applied with sovereign immunity.
And during that time, there was a war happening. And while that occurred, then the forcing of the treaty being signed occurred at the same time.
And why was it signed?
Because they were in the eye of the war, in the middle of the war. There also occurred a separate, also inclusive situation where the militias went ahead and took that opportunity to get them to state their land as Azerbaijan's. Yeah, as a whole.
Was it a violation of international law when other countries intervened in the war, such as Pakistan, Israel?
In our argument, we presented the Vienna, which gives a guideline on how treaties should be, how treaties are illegal or legal, and based on that, we know that the treaty is not void. It's void. It's not. It holds volume or lacks
legal standing.
Yes.
Was the treaty influenced by the intervention of other nations in this war on the side of Azerbaijan?
So other nations are allowed to intervene when it comes to helping with wars. I mean, there are several times where the United States does send over help to other nations. However, we know that this case is between Azerbaijan and Artsakh, and the influence of them believing that they are one entity, when instead they are two entities, because it was a coerced treaty and signed.
Okay, thank you very much.
You're welcome.
Okay, appreciate that. Hopefully we understand that this is a learning process that they're trying to do. One of the things I think we might want to mention when we're answering the questions here, the basis of Azerbaijan and the basis of Turkey's claims happens to take place on December the 2nd of 1920. On December the 2nd of 1920, the Republic of Armenia, the First Republic of Armenia, was going out the door. And inside and coming in the door that same day was the people that ends up becoming the Armenian Communist Party, and they were forming their own government. Well, the the Turkish army that had invaded the Armenia, the First Republic of Armenia, was actually a rebel army under the Grand National Army, I guess you would call that. They made the Republic of Armenia sign this treaty, forcing 60% of their land to be given to the Grand National Army, or the Grand National Assembly there in Ankara. Well, the problem being is that they were not an official signee, or they were a non-state actor. And according to most all conventions, you cannot have a non-state actor sign a treaty for a state that doesn't exist yet. And then so you have that issue, plus you have the issue of coercion. And their basis of their whole claim has to do with coercion. Then in, I think the Treaty of Moscow and the Treaty of, maybe Kars and Moscow, I'll get those two confused real quick, but they give away this land that we're talking about in Eastern Armenia, because it wasn't contiguous to their property, to Russia. It was contiguous to some of the deals there, and they were given for weapons and food. So the army was trying to still overthrow the Sultan, and which was the legal government. So they had a treaty. The first treaty was signed between, which is really crazy, between Mustafa Kemal and Lenin, because Lenin wasn't the official government of Russia at that time. So you had two personal treaties, and then later was reinforced with the USSR. And the USSR in 1922 gives the land to the Azerbaijan SSR. And that's where we have, I always pronounce it wrong, so I know I'm going to get killed, but they give that land to the Azerbaijan SSR. Well, that's the first time, 1922 until 1990, they were part of that country with the capital Baku. There was not a country of that name until 1922, or not, yeah, excuse me. So when they created that, they were created a country. Then in 1977, the Constitution of Russia was changed, and they allowed how you could break out of Russia. Well, the problem being is that although the Constitution of Russia, I remember as a student in high school, it's a beautiful written document. You couldn't follow a lot of it, okay? So you had this beautiful document, and they tell you how you could get your freedom. Well, the problem being is that since most of the time the guns were pointed towards people, you couldn't really get your freedom, but they show you how you could take yourself out of the Russia. Well, when the Russia fell and all of a sudden all the guns were not pointed towards people, it was like a domino of every SSR was pulling out and becoming independent. So they also had the deal that autonomous areas inside of the SSR could often vote for the same independence. So at almost the same time, or very close to the same time, the people in Baku had their referendum, and the people in Aktash had their referendum, and they both become independent republics. Now, as Tateos was asking you the questions, the problem is not whether the other people recognize it, it's whether you recognize by the legality of it. So let's sum this up real quickly. How can you have a legal argument correctly if it was based on not falsehoods, but was not based on the correct principle? If you look at this, there was no Azerbaijan until 1922. In 1922, that land was given to Russia illegally, and then we had that. So then you go back and look at, okay, we have the Constitution. Constitution says you allow this. In 1990, they have a referendum, and in 1991, they have a republic. So technically speaking, it doesn't really make a difference who else recognizes it. They are actually an independent republic, whether you're recognized or not. You know, just like the United States was not recognized immediately by different countries, but, you know, we were independent from Great Britain. So this recognition is going to be kind of like a false dilemma, but, you know, that's what the situation is. That's what we're trying to learn about. You need to always go back to the fact of what is legal and what is right and what is accepted. That's why I started out the comments today about Crazy Legs Leroy Hirsch, and I thought it was kind of interesting because a lot of people will be listening to this in Glendale, and they're Los Angeles Rams fans. And my good friend up there is a New England Patriot fan, and I thought maybe this would be kind of a neat Armenian East Coast, West Coast type of deal, because if they were going to both play. But the situation is that sometimes you don't listen to what people are telling you. You have to seek out the truth themselves. And that's what this whole lesson is all about. We need to seek out what is true. The bad part about it is it's not our four people here. It's not Kevin in San Antonio. It's not me here in Austin. Or it's not Tateos up in New Hampshire. We have leaders in Washington, D.C. We have leaders in Yerevan. We have leaders in Baku that do not even know or understand what we were talking about today. And they, for one reason or another, say, well, it's not accepted. Well, the problem is accepted Shemektic. You know, if Leroy Hirsch had accepted the fact that he couldn't play football, he would never have, done what he did. So, we gotta seek out what is actually true. Does that make sense, Tateos?
Absolutely. I always say that truth is like a wine bottle cork. You can take that cork and bring it all the way down to the bottom of the ocean and hold it there. And while it's being held there, no one sees it. But you let go of it. And like the truth, it rises to the top and people can see it. The truth may be hidden for a long time. And it has been hidden for a long time on a number of issues. But never, ever, ever allow it to be hidden forever. Do all that you can to uncover the truth, no matter where it leads one. It has to be told in that understanding of truth will prevail and shall prevail and needs to prevail. I just like to congratulate both teams on the presentation that you made. And again, I say on behalf of all those that I mentioned before, thank you from the bottom of my heart. God bless you all.
Tateos, if I ask like a quick question, what does a person gain by learning something like this, or how can this help students and
obviously you young ladies have studied history. Have you ever seen anything like this happen before? It repeats itself. You see it happening on the streets today in our country. In our country. Do you think there's a lesson to be learned from what happened in Artsakh, what happened in Minneapolis, what happened in this country with the Native Americans, what happened in Africa and many, many of the countries there with the suppression of the European countries?
What I have learned is that regardless of others' recognition of you, you have to prove that you recognize yourself and maintain that, and you will find a new path, or like your own path.
Good.
yeah, that
Very
would go really well in Yerevan right now, because one of the things that aren't recognizing is Armenia is not recognizing their responsibility towards their own country. So, I mean, unbeknownst to a lot of people here, the United States is trying to force another treaty on the different parties to just totally go against the 1920 treaty and give up all your rights. So, this is something that's being fought in the back halls right now, I guess, of the different political deals.
To tell you how bad it is. Tell you how bad it is. People of Armenia that lived under the Soviet government have said that those days were better than what we are facing today. That's really bad. I lived 1 year under the Soviet Union when I was a student in Armenia. And I know how difficult it was to live under their rule during that time. And it was supposedly one of the better times is during Brezhnev's time. But
Yeah,
people
so,
think that those days were better in a number of ways than what the people in Armenia are facing today under Pashinyan. Very similar to what we're facing under the government in Washington right now. And it's not pleasant for anyone.
uh, I would like to see ask a question, and you could talk to Tateos real quick. Amanda, tell a little bit about the background and where you come from every morning to go to school. Amanda?
One second, please.
Okay.
Yeah.
Hello? Okay, perfect.
Yeah.
So I myself am part an American citizen and a Mexican citizen. So every day I have to wake up at 4 a.m., 5 a.m. just across the border and come to school, like just to study. That's my main obligation. And eventually crossing every day, you have this contrast of cultures. You have this contrast of perspectives, especially, and different stories you meet when talking to people in the rich or just waiting in the bus stop. And I find it how important it is to stay together, especially in these times, to create maybe a sense of community and always seek the truth, even if it has some sacrifices for it.
Beautiful.
Thank you for sharing, Amanda. I didn't know this school is on the border between the United States and Mexico, and Amanda comes every day from Juarez, and she has to take a bus to go across the bridge, then take a bus from the bridge to the school. So, there are people that are going 2, 3 o'clock in the morning, and then go to school and come home at 8, 9 o'clock at night and stuff like that just to come to school. So,
Don't give
you
up.
have that.
Don't
Yeah.
give up. It's tough,
And,
but don't give up.
And anyway, she actually spends time after school trying to study this too. So, we have issues to where English is not the first language for a lot of the students, and they're learning English by doing this, and we're learning about law, and this is a good learning process. So we really appreciate the opportunity to do this today. I think this is a good symbol for today being Genocide Awareness Day, that we actually talk about a genocide that a lot of people aren't talking about. And we're talking about some things that should probably be mentioned that people have forgotten. And since that's remembrance, that's a good deal. I appreciate the time. Thank you so much. Kevin, Dr. Cunningham, do you have any comments?
Sorry, I'm trying to unmute. No, I don't have any comments at this time.
Well, explain to us a little bit about how this way of teaching actually has influenced maybe you or some of the students.
Well, it's kind of difficult. You're being the teacher there in El Paso, then you move to San Antonio, and you have to do everything online. So we have to wait an hour to get for them to catch up. So that's the difficult part. And then I think that's the most difficult part, though, really, to be honest.
Okay. Thank you so much about that. I think at this point we'll try to honor everybody's time and try to say that. Gio, would you like to say something on the behalf of that and thanking? And then we'll have Jordan's team say the same thing, and then we'll thank everybody. Gio, go ahead and say it.
Okay, so hello everyone. I am the founder of this debate club, and founding this, I had a very different view of how this would occur. However, what we're doing today is more than I ever imagined. It's incredible. We're making a real influence. We're learning about things that we were oblivious to months ago. And it's really important to recognize that these are people's lives that we're fighting for. And I'm just so happy that all of us can come together in agreement and accordance to what it is that is occurring. Hopefully that there's a change being made, that there's a change that will be made. And thank you all for your time today. I don't take it for granted.
Yeah, Jill, could you tell us a little bit about your background?
Okay, my background. I am from Nairobi, Kenya, originally. I came to America when I was 7 years old. I still have my own Kenyan community, that we visit every weekend or so. We celebrate the holidays together. And other than that, my bigger community has been this community at school, full of incredible people like Elisa and Jimena Batres that come from Hispanic culture, but Jordan Hamill uh, comes from a black culture, and it's a very nice school. I will very much miss it. Always come back and visit it because I am graduating, and yeah, that's pretty much it.
Yeah. Jill's a senior. When you talk about community, why is it important to remember where you came from?
Oh, well, it makes you you. It makes you unique, and where you go, you have something different to offer. And I mean, it's where your heart is. It's where your roots are. It's very important.
Okay, now how does that relate to what we're trying to talk about today?
Well, just like how there are trials happening in Africa, there's trials happening everywhere, and it's very important to recognize that no matter where you are, no matter where you come from, because people remain people, regardless of whoever's background. And we must fight for those people, regardless of whether we're among them, whether we've heard of them, whether we've joined them. Yeah.
Very good. Thank you so much. Okay, Jordan.
Hello.
Okay, tell us what you guys learned.
Okay, I'll start. So again, my name is Jordan Hamill, 17. And for me, I am Black slash African American. I am not of African heritage at all. I'm born and raised in El Paso, and my parents are from America. So it's been a very eye-opening experience for me because I have never really had that cultural difference in terms of like cultural struggle and political internal political struggle to where it would separate my family, if that makes sense. So it's very eye opening for me to be able to hear and just to actively see people like Jimena who have to cross the bridge every day, what they have to do just to get a simple education, which is something I never had to think about, which is something that I feel helps me gain a better perspective when I think about the world and the people that are in it. And like Gio said, like people are people and your roots like create different experiences for everyone. And I believe that that is such an important thing to have nowadays, where we see what President Trump is doing. We see the conflict that we have with Venezuela, with Cuba, with Iran and Iraq, and all these people who have a lower quality of life than us and a greater struggle to the point where they have to think about everyday necessities that people in America tend to not have to think about. So I really do appreciate being part of clubs and organizations and just activities like this to where I can better expand my mindset and understand and just be more open minded about the privileges that I have as an American citizen and about somebody who's been born and raised here.
Very good. Amanda, do you want to add anything?
Well, I believe that Jordan explained it pretty well. As more as personal challenges, of course, there was this language barrier that some people have to face every day. Me and Elisa come from an Hispanic heritage. Our first language is Spanish, and with the help of this society, we would make great changes, and we are improving every day. We are learning to include pathos, ethos, and logos, yes, and how to use them so we can benefit and how we can help other people, how we can create awareness so people can take this blindfold of luxury, I believe, and privilege, and just be more open-minded and conscious of their actions and what is actually happening in the world historically.
Thank you very much. Tateos will give you the last comments. What did you learn today by doing this with us?
Well, like I said, I'm impressed by the intelligence of these young ladies and their determination to see that the message gets out there. I'm really impressed by, am I pronouncing Jimena right? Okay. The ordeal you have to go through just to get an education. Bravo to you. You ladies are phenomenal. You have a fire in you that I hope never goes out. I hope you become infectious to others, that you create an interest in the minds of others on what is right and what is wrong. It's funny, you were talking about the language situation. When I was born in this country, my mother and father spoke only Armenian in the house so that I would learn Armenian. And when I went to kindergarten, I didn't know a word of English. And they were going to put me in the class, special class, because I didn't know anything. I couldn't speak English. And the teacher sent a letter home to my father and mother, and they said, this is a problem. So I can relate a little bit, even being born in this country. It is difficult. It took me a while to get caught up with the others. Just don't stop doing what you're doing. Don't stop doing what you're doing. I have no other message to say to you all than that. Be infectious to others. Michael, you keep doing what you're doing. And someday, with the help of God, our world will be a better place. God bless you all.
Thank you so much. Thank you so much for everybody, and we will see you next time. Thank you.
Thank you.
Bye-bye.
Bye.
Hey,
Bye.
bye.